how do you draw the distinction between what is the assumptions that are in the service of the text and those that open the door wide to judicial interference or fiat?
Some of them are just standard manners in which people understand language, okay?
Right, got it.
And that's one whole category that the others can't complain about. Other ones are so traditional, they have been around so long, that anybody who's a legislator and writes a statute ought to know that that's the way it will be interpreted by the people and by the courts. An example of that is the proposition that when you have a listing at the end of the thing, at the end of a passage, which says something like dogs, cats, gerbils, parrots, parakeets, and other animals. That generalized term will not be interpreted to mean elephants. It will be interpreted to mean other animals of the same sort, namely domestic animals, pets. That's an ancient principle.
It's almost a question of legal grammar.
It's almost legal grammar, right. I can't say that, that every English-speaking person would understand that automatically, but every English-speaking lawyer would certainly understand that that's how courts have interpreted a phrase of that sort for hundreds of years. You should not interpret language strictly, nor should you interpret it sloppily. You should interpret it reasonably. Strict constructionists give a bad name to serious textualists who say language should be interpreted reasonably. The First Amendment is the example I always give. If you were a strict constructionist, you would have to believe that Congress could censor handwritten letters, because all the First Amendment is that Congress may abridging the freedom of speech or of the press. A handwritten letter is not speech, it's not the press, so it can be censored, right? No. I mean, a proper understanding of the First Amendment is speech, press. It means there's a figure of speech called, I see a sail, where the part stands for the whole.
Yes, right.
Is that synecdoche?
Synecdoche.
My God, that's brilliant.
Did
you have a Jesuit education?
I did not, but I grew up in upstate New York where the English teacher just said think of Schenectady.
Ah, I see. Yeah, it is. It's
all right, so synecdoche.
Synecdoche, and I think speech and press are synecdoche, standing for the conveyance of ideas, expression, whether it's done by semaphore, by Morse code, by burning a flag, so long as it's your own flag. You're free to express yourself.
The false notion that committee reports and floor speeches are worthwhile aids in statutory construction. Close quote. Mr. Justice Scalia, you have no interest.
How much time do we have?
You have no interest in probing the intent of a legislature.
We are, as the famous line from the Massachusetts Constitution says, a government of laws, not of men. We're governed by the laws that Congress enacts, not by the unexpressed intent of whoever wrote them. And if they meant up when they said down, that's their problem. Frankly, if the legislative history is utterly clear about that, too bad. We're governed by the laws. So that's point one. You shouldn't be worried about their intent anyway. You should be worried about what was promulgated to the people. That's what they're governed by. But secondly, even if you were interested in legislative intent, are you going to find that in legislative history? For one thing, in a multi-member body, it's very hard to understand what the intent was beyond the words that they all voted on. Other than that, they could have voted for them for very different reasons. Just because one or two of them say, oh, I think the language does this, the rest may not have felt the same way. So the notion that you can pluck statements from a couple of legislators or even from a committee report, which is usually written by some teenagers, and And not even
members of the Federalist Society, if we're lucky.
Not even very often, not even read by the committee, much less read by the whole House, much less read by the other House. The notion that somehow is reflective of the intent of the whole Congress and of the president who had to sign the thing. I mean, it truly is the last surviving fiction in American law. There used to be a lot of fictions, you know. This is a fiction. You have to engage in a willing suspension of disbelief to accept that.
The false notion that the living Constitution is an exception to the rule that legal texts must be given the meaning they bore when adopted. Close quote. The argument, of course, is that the framers were wise men. They understood that they were constructing a document for the ages, so they left a little play in the joints. They permitted this thing to breathe, to expand, to adapt. And the body charged with executing these expansions and adaptions is the judiciary.
Yeah. No, they knew that there would be need for change, and that's why they had an amendment provision, as some constitutions did not. This Constitution could be amended. And if you listen to John Marshall in the Bank of the United States case, what enables the application of the Constitution to new situations that can't be envisioned by the framers is not the ability of the courts to change the meaning of the Constitution, but rather when the courts interpret provisions of the Constitution, they ought, as John Marshall said, to give those provisions an expansive meaning because they have to be used in situations that cannot possibly be envisioned now. That's the way in which the Constitution is expandable and flexible, not by being amendable through the courts. When you have terms in the Constitution that are not ambiguous in the sense that they can mean one of two things, but rather are general, so that they could cover a lot of things, you should interpret them not to cover the things that the people who adopted that provision did not think they covered. And, you know, cruel and unusual punishments is one. Of course, those words could cover a lot of things, but it's clear from the history of the times that nobody thought that it included the death penalty. Nobody. And it's the same thing with this right of abortion, whether it's founded in the 14th or, I mean, God, the 9th Amendment, forget about it. Nobody ever thought that, I mean, just look at history. All the states had prohibitions on abortion for hundreds of years. So when was it that the American people made the decision to forbid a state from adopting such?
They never did.
They never did. The court made it up. And you know, we're not talking about the right or wrong of the substantive result. I mean, I'm quite, you know, neutral on that. The point is, who should decide? Should it be a question on abortion, whether people try to persuade each other that there ought to be, or there oughtn't to be, and put it to a vote? That's fine. That's, you know, if you want the right to abortion, create it the way most rights are created. In a democracy, you persuade your fellow citizens, pass a law. You want to abolish the death penalty, the same thing. But all of that democratic choice is taken away when the court is enabled to give vague provisions such as due process of law, equal protection of the laws, meanings that they did not have when they were adopted.